Welcome to today's segment on Tort TV. Today we'll be exploring the complex area that is medical negligence. Unfortunately, this particular tort is neither punished nor adequately compensated under the current system in Australia. We will criticise the current state of the law, analyse the effects it has on policy and social factors, and suggest that the law could implement a no-fault compensatory system. Unless, however, situations arise where the conduct of the doctor is significantly reckless. An experienced attorney from Brisbane will feature as part of this documentary, alongside a current general practitioner who will share his perception on medical liability.
I'm Martin Bull. I'm a general practitioner in the Gold Coast. I'm a self-employed general practitioner. I contract myself to 2 surgeries, one in Ashmore and one in Upper Kimberley.
Hello, I'm Charles Hartley. I'm a solicitor. I currently work in-house. I'm Head of Legal Services at Metro North Hospital and Health Services. I worked in London for 10 years as a litigation lawyer, specialising mainly in healthcare litigation, with some insurance too. So I do have general personal injury litigation experience as well.
Section 22 of the Civil Liability Act virtually ensures doctors are excluded from liability if, at the time the duty was performed, is considered to be widely accepted by other professionals in the field. Section 21 of the Act provides a duty for doctors to adequately warn their patients of all risks involved before they consent to a medical procedure. If they fail to carry out this duty and a patient commences an action for negligence, Section 22 will not apply and a judge may find the doctor liable.
At the end of the PIPA process, the compulsory conference, the claimant has to decide whether they want to risk going to litigation. Litigation comes with risks, costs, risks. If you lose, if you do not better an offer made, you stand to pay the costs. Quite often the costs will outweigh the claim itself, and that will be the cost of the whole matter. The cost consequences of abandoning a claim are none. There's no obligation. If you drop your claim, that's it. You're not forced to pay anyone's costs.
It is very difficult for patients to prove that the doctor has not met the expected standard of care because this standard is largely dictated by other medical professionals in the field.
To GPs who've been on the Gold Coast for a while, they say that a lot of the interaction between a lot of general practitioners is very limited now. So unless you volunteer to go on committees, then you probably do work a little bit in isolation. Even within your own practice, you tend to focus on your patients and what goes on.
It is particularly difficult for them to prove that the breach has made a material difference to their outcome. In this instance, the judge will decide subjectively, in light of all the circumstances of the case, whether or not to impose responsibility on the doctor for the harm caused. Therefore, the judge has significant discretion as to whether or not the doctor should be held liable for their conduct.
They're probably not negligent, they're just probably flippant and probably, in my view, lay themselves open to claims in terms of their lack of thoroughness. Often a lot of the cases you read about are in the medical press. About cases they've been involved in. I've had a patient who was a doctor who was involved in claims against him, grounds of poor medical behaviour. I've had a patient who was effectively abused by a doctor, and it was amazing that he was allowed to practice when they had the different state rule, and he was barred in one state and then allowed to practice in another state. The patient actually told me about what happened. It was a big legal case that she was involved in.
Okay.
But interestingly, when I came away from South Australia up to Queensland, I suddenly heard this doctor who'd been barred in South Australia had been practicing on the sort of Queensland, New South Wales border.
Okay.
Even though he'd been banned in another state. They've laid down that if you feel that you're working with a negligent colleague, you're supposed to report them.
Mm-hmm.
If I ever did it, I think I would probably go through my medical defence organisation first before I did anything like that.
Yeah.
And I tend to sort of go through my medical defence for anything I need to do first. Me personally, I mean, I try to be as thorough as I can because you never know which patient you see, even if you've had a good rapport with them for a long time. If you make a mistake, then you may be liable for going down complaints commission or liable towards APRA.
Yeah.
So I regard every patient as a potential legal case through the door.
The tort system is supposed to punish the wrongdoer and compensate the injured person. Under the current liability system, indemnity insurance protects doctors considerably from financial punishment. This is a practical policy adjustment as it enables them to practice without feeling impeded or restricted by legal concerns.
I suppose we see most of the legal cases and stories from America, and some of the negligence claims and the payouts they get for some of the alleged negligence, I suppose, scares you a lot. And as I said, I regard every patient as a potential negligent case, and so I think in some ways you work. I mean, you work to your best of your ability, but in some ways, I suppose, in the background, there's also an element of slight fear that you don't want to sort of do wrong.
Mm-hmm. Okay, so does that impact on your practice, how you conduct yourself?
Yes, I think probably with the patients you get a good rapport with and you know over a long time, you come in, you keep your eye on them, and you make sure that if something new comes along, you investigate. But generally, you almost relaxed as friends in some ways. But new patients you haven't seen before, you tend to sort of practice more defensively, and any new presentation, you tend to practice that.
As a doctor, do you feel adequately insured against claims of negligence or patient injuries?
I hope I am. I suppose I rely on my medical insurance company to. They supposedly are offering me the optimal cover for any negligence claims.
Because of this, the patient is often the person who endures the burden of commencing litigation in order to seek their compensation. Professor Richard Lewis has written extensively on this fault-based system. He says our propensity to claim is thought to have increased to such an extent that we are now seeking personal injury compensation on a routine basis, regardless of fault.
The state's indemnity is far-reaching. It's very hard to be denied indemnity by the state in Queensland.
Okay.
It's under a policy, the state indemnity policy called IR2. It's not like a normal insurance policy. It's very vague in places, and all kinds of doctors have been indemnified in certain situations, and the threshold of willful neglect is very hard to meet to be denied indemnity.
Often complaints are simply a miscommunication between the doctor and patient, who is simply looking for validation. There are internal working processes that could minimise these types of complaints. However, the patient will often seek legal advice before approaching the hospital.
Over 25% of all complaints to any hospital, it's all about communication.
Okay.
Often what happened was never negligent, could never get close to being called negligent.
Yeah.
And it's it's really that the patient doesn't feel validated.
Okay.
And that is a problem. Even where things have gone wrong, they can be managed, and patients will not bring claims if sometimes if they're recognised and the hospital fesses up.
Yeah.
And a common theme in many healthcare complaints is that you never listened. You never accepted you were wrong.
Yeah.
And they feel going to court or bringing a legal claim is a way of
getting them to fess up.
Yeah, getting them to fess up and own it, and it gives them validation for their initial complaint.
Yeah.
Because they won't listen to it. Medical stuff, when they deal with it, it's a double-edged thing. Yes, they'll deal with the patient, but by the same token, if they see where things have gone wrong, they will look to rectify systems. And there are internal committees within a hospital, internal processes that learn from these things. They feed into safety and quality, critical incident committees, and they have de-identified reports. And safety and quality gets to work changing policies, processes
within the hospital.
Yeah. And you also have root cause analysis tools, which is all about improving stuff. It's governed under Part 6 of the Hospital and Health Boards Act. But by the same token, if it's just not so much a systemic issue, we've got a problem with the doctor, then they'll get on with that too. And internal disciplinary procedures, counselling, putting them back on track, and possibly referral to a professional body.
It's interesting, I worked with an older doctor who was in his 70s, and I suppose he took the old-fashioned approach that the doctor's word was the doctor's word, and what he said went. And it's interesting, he was regularly written to by APRA about complaints. But again, he seemed to sort of bounce those off and just continue as he wanted.
Queensland has an open disclosure policy. However, PIPA is silent on witness statements, enabling parties to seek ongoing expert evidence after submissions have been made.
And so it's the evidence they obtain. They can keep getting expert reports until they get the one they want, and the other side is none the wiser. That's the issue. I mean, they're not obliged to follow them.
Yeah.
Particularly if it doesn't accord with common sense. But they are swayed, and often the judge is swayed by a more persuasive expert, who's not necessarily a correct expert.
This inevitably enables legal experts to draw out litigation, which effectively makes it more costly and more difficult for the plaintiff to succeed in an action.
But remember, some cases are settled simply because, to use a blunt expression, for economic reasons.
Yep.
We can often say, look, we don't think you've got a leg to stand on, but it's going to cost us time, doctors' time off the ward where they should be. It's going to put our doctors through stress, and it's going to cost the state a lot of money just to run a trial for a week or two. You're talking several $100,000. And are you going to get that back off a claimant if you win? Almost certainly not.
As a means of compensation, our current system is highly inefficient. The more culpable the clinician, the less likely they are to proceed to litigation, as breach of duty will usually be conceded.
Ironically, it's less stressful for them the more negligent they are, because liability is more likely to be conceded earlier on to save costs, meaning their involvement in the case ceases.
Okay. And it's stressful for them to be in court?
It's very stressful for them to be in court, and the whole run-up is extremely stressful.
Our current fault-based compensation system encourages plaintiffs to malinger, overstate, or dwell on their injuries, and is particularly stressful for both parties.
Even if they don't mean to, they're encouraged to fully state, if not overstate, their injuries.
Yeah. Because
this is their one shot at getting compensation. It's an incentive for a claimant to exaggerate their injuries.
Yeah.
Deliberately or subliminally, you get rewarded for not getting better for the 2-3 years that your claim goes on.
After considering these effects, we at Tort TV have considered ways by which the law could be reformed. Firstly, Australia should introduce a no-fault disability jurisprudence scheme that grants benefit for medical injuries regardless of whether the doctor is at fault. Secondly, a system could be imposed whereby 1. Only injuries sufficiently serious can be taken to court, and all that has to be proved is that the outcome is not one that would have reasonably been anticipated from the treatment. 2. That damages are awarded on a tariff basis. And 3. When appropriate, the adjudicating panel can refer a healthcare practitioner to the Health Ombudsman for professional disciplinary action and possible practice review or restriction. This would remove entirely or grossly restrict legal fees, see errant doctors disciplined, and where appropriate, have their practice restricted.
Could there be any changes that help you practice without feeling impeded by the law or being sued?
I suppose they'd almost have to have almost maybe a set of guidelines, almost to say that, you know, if you are following these guidelines, you are okay. Whereas we don't really have any sort of guidelines other than do best practice and make as much notes as you can. As many notes as you can. And sometimes I suppose you've got that fear in your background all the time, but if someone came to you and said, reviewed your cases and reviewed what you write about patients and saying, well, this is adequate and inadequate, maybe that would be helpful in terms of helping practice and saying what you could improve and what you couldn't improve.
Yep.
I've been to one medical defence sort of meeting one day, and basically they said no notes is no defence and some notes is some defence. But it'd be nice to know if someone came in and reviewed the situation.
What exactly they want to do.
What exactly, are you doing best practice? Obviously, they can't necessarily comment on your medical knowledge and background, but they can comment on how you write things and how you approach things.
Yep.
Would be maybe a useful thing to sort of allay a little bit of fear.
I'd like to see the process made simpler. I think a step in the right direction was making Queensland an open disclosure jurisdiction similar to the UK. I don't agree with the New South Wales system. Of having to subpoena everything.
Yeah.
Having said that, you could perhaps take a step back and say, well, and look at New Zealand and say, well, actually, should these matters ever get to court? Because in New Zealand, you cannot bring a personal injury claim through the courts. It's gone. It's all Accident Compensation Commission.
Yeah.
The ACCC or whatever it is, which is a more prospective view of things, that they want to get people back on their feet. I think things could be improved in Queensland substantially by changing court practice procedure. That could be adopted in the personal injury proceedings procedure, where you have a mutual exchange of witness statements as to fact, and thereafter you have an exchange of expert evidence, and it's regimented as discipline, so people don't keep going back and getting further opinions when they receive something. So once you've got all your witness statement evidence in and your documents exchanged, then you put that before your experts. They give a view on all of that. You get their views. You then get the experts to meet, discuss the points on which they agree and disagree. So all the time, issues are being honed out. You should have your small clutch of issues that remain to be resolved. And that would work well in the PIPA process, and it would also work well in court, in the legal, formal litigation process.
The extremely expensive and long-winded process of court proceedings and the uncertainty of the law make it very difficult for patients to succeed in medical negligence claims. The doctors are heavily indemnified so that any claims against them are covered or protected as part of their insurance policy. Therefore, the liability and financial effect of medical negligence claims on doctors is minimal. Under this process, conduct is poorly regulated and the tort system of compensating personal injury is ineffective.
Well, tort enthusiasts, that brings us to the end of today's segment. We hope you feel more informed on the practical implications of tort law in Australia.